Hello, everybody, and welcome to Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reitshtein, I'm Dan Bemel, CDFA and financial advisor, and thank you all for joining us. During each live episode on the first Wednesday of every month, we'll explore our guests' personal history, their professional story, dig into a meaningful legal topic, and hopefully putting together an entertaining lunch hour along the way, get to know our colleagues a little better. Before we begin today, a few housekeeping announcements.
Thanks, Dan. You will receive your MCLE certification shortly after the program. Please take a moment to complete the survey that's included with your certificate. The Family Law section is sponsored by SoberLink, White, Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. SoberLink's system combines a portable breathalyzer with wireless technology. Trusted for use in child custody cases since 2011, SoberLink is the only system that combines court admissibility in all 50 states and Canada, facial recognition and tamper detection, real-time results, and easy-to-read advanced reporting. Trust the experts in remote alcohol monitoring technology for your custody cases involving alcohol. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. We thank our sponsors, and now let's begin the program.
All right, thank you, Lauren. Our guest today, the very first in our direct examination series, is Chris Melcher. For our legal topic today, Chris is going to take us through one of his career-defining cases, Marriage of Valley, well-known case involving celebrity and tragedy. And we'll hear background and behind-the-scenes details Chris has never before discussed in public. We'll also talk about some of the key moments in Chris's personal and professional life, including how he almost went bankrupt as a criminal law attorney and how he ultimately found success in family law. But before we get into all that and a little bit on the business side of practicing law, let's start out by talking about what's going on right now and the state of the family bar. Chris, welcome.
Well, thanks.
Welcome.
Thanks,
and
Dan.
Thank you so much for joining us for our launch of this series. So let's jump right in. What is your assessment of where things stand for the bar and how that's changed over the last year?
Well, thanks, Dan, Lauren, for having me. And I'm seeing so many friends and colleagues that are on with us here that I really appreciate all the support that I've received through my career. And I think that where we're at in family law right now is a place of transition where there's a lot of firms that have been established a long time ago and led by folks who eventually are going to retire and then who's going to take over. And so I think we're going to see consolidation and growth. And there's really here for the taking. I think that this market is so huge. And we've seen even during these really, really challenging times that we've been through the last year that we're mostly super busy. So I think that there's opportunity. And that's one of the things I want to talk about here today is how do we leverage that? How do we up our game as family lawyers and get to that level?
So how are you doing that? How is your firm trying to meet that moment?
Well, it's for me personally, it's been really adapting to video and which I'm loving because before I was doing a lot of travel for speaking gigs and also for cases that I was handling all over the place. And I really never realized how disgusting it was going into these airports and hotels and Ubers. And I'm really loving not having to do that anymore. And so I really embraced video. I set up here in this is just a studio here in my office that's just for video. And we've set up now 2 other rooms that we're using for that now. Before, we didn't have that technology in our office. We were setting up conference rooms in individual offices. Now we're basically setting up studios. And so that's one way, because I think video appearances are here to stay. Video conferencing is here to stay. Much more efficient for the client not to have to bill for waiting and travel time, and a lot easier on us not having to go do all of that travel. So that's one way we're pivoting. And then also just in growth, because the demand is so high. And so we're trying to grow. Our numbers were a little bit down, and we're trying to get them back up to probably 10 lawyers.
So do you feel like the rest of your firm is embracing that, or was that a big sea change to get that to filter down throughout the whole ranks of the firm?
Well, I think everyone is adapting to it, and obviously in different ways. Some folks work remotely really well. Other folks like to be in the office. For me, I like to come in and have that separation from home, and so I think that has been a good adaptation for all of us to see that that we can work remote, because before we were all in person and we didn't really know how to work remotely unless we were on the road. And so now we can make it easier on folks. So if they want to work remote, they can have that option. We can recruit from a bigger area, because my firm is in the West Valley, and it's a lot of people don't want to drive out here for a job. And so now we can recruit maybe anywhere from California for the best talent, and potentially work remote.
And Chris, when you said you think that video is here to stay, when we have the option to go back to court more regularly and safely, do you think that people are going to continue to appear via video, or that we're going to go back to business as usual?
Well, I guess it's up to the individual, but for me, if both sides are on video, at least you're on the same plane, and you don't have that advantage of somebody being in person and the other on video. So I'm hoping it's here to stay. Honestly, I hated going to court, and mostly because I lost most of the time that I went there, but it's actually the building and the parking and the traffic that I don't need to see that again.
Well, do you think there's something that is missing, though, from these video appearances in terms of the interpersonal connection between counsel, just in the hallways and having all the parties together?
It could. There's some benefits. I mean, if in a domestic violence restraining order hearing, there's some benefits of being on video. It's more protective to the victim, and we get to see each other maybe a little bit better on video than we would in person. I think the court has a better ability to see facial expressions when somebody's on a clear image on video, rather than being on the side and watching their profile from the witness stand. So, there's good and bad from it. It's certainly easier for the court to mute somebody on video or turn their video off than it would be to get them to stop talking in court. So you take the good with the bad.
Do you think there's a big difference in that for self-represented clients?
Well, that's the biggest struggle, and because not everybody has access to the equipment and the internet connection. So that's one thing. But on the other hand, we're making people go to court for traffic tickets and relatively minor appearances, status conferences, that they would have to take the day off of work. They'd have to get childcare. They'd have to take a bus to go into court and wait a long time. But if they're on video, they could keep their job, that day, and just log on when they're needed. And so I think that there's less impact on self-represented litigants if they're able to access the LA Court Connect.
So I want to go back to one thing you said at the top about the opportunity in the family law market. And I know we're going to get to a little bit more of the business management side or the practice management side later on today. But for the younger attorneys listening, what would your advice be there in terms of seizing that moment and thinking about those opportunities, maybe in a more systematic way?
Well, I think it's thinking big, because if you're starting your career, you're charting it out, you're in your 30s, 40s, and you're saying, hey, I can see I love family law. I really like this practice area, and you want to grow in it. The opportunity is absolutely there. So for me, and obviously you have to make a goal that works for you. My goal has always been to really be the top family lawyer, among the top family lawyers. I wanted to make a lot of money, and I was willing to sacrifice my personal life, unfortunately, to make that happen. That's not really a great choice, but if that's your choice, you definitely could dive into this and take that market share. If your goal is to, have more of a 9-to-5 job, then obviously that's going to be different and maybe better personally, but you're not going to kind of take over the market doing that. But if you wanted to grow in this practice area, I am seeing, and as everyone else is, that firms that are going to go away, and the firms that are led by one or two people who eventually are going to retire, and there's no clear succession planning in that firm. And so who takes over? And I'm not talking about a 1 or 2 person shop. I'm talking about more the 5 to 10 to 15 person firm being supported essentially by 1 or 2 attorneys. And so if there's no clear succession plan, that firm eventually goes away. There's a void that can be filled. And I'm suggesting that others could come in and easily do that.
So I want to get to more of that kind of secret sauce of how you would build and how you would run a practice later on. But take us back in time a little bit first. When did you know that this was your calling? When did you kind of, either in the law or family law specific, when did that really strike you?
Well, I never wanted to be a family lawyer. This kind of came as a surprise to me. But I always wanted to be a lawyer as soon as I started thinking about my career. And that was because of my dad. And he was a deputy district attorney for LA and doing homicide trials. And when I was young, and this is, in the mid 70s, and I'm probably, 7 years old or something like that, he started talking to me about his cases. And so he would be preparing for trial or in trial and talk to me about what the facts were, and asking me what I thought. And he was genuinely interested in my input. And so that kind of got the legal juices flowing really at a young age, and talking to my dad about these cases that he probably shouldn't have been sharing with me. But that conversation went on and on and on, and it just sparked an interest here in law, and also gave me an advantage because I knew what a lawyer did. And what I've seen is, when I taught a law school class last year and talking to folks, many of them that never met a lawyer before, and they know they want to be a lawyer and obviously in law school, but they didn't really know what it is to practice law. And I saw my dad go through a lot of difficulty at the DA's office and then in private practice. And so I got to learn from that, and that's where it got started. And then, like I say, the family law thing was more of a fluke, but that was not my career path when I started out.
So do you remember, when did you start making those arguments, right? When did that kind of part of your brain, you talked about it as a 7-year-old at the dinner table. Walk us through some of that progression, how you ended up going to law school.
Yeah, so it really started in, I used to get in trouble a lot as a kid. And then when I found myself in detention, waiting to speak to the principal, there were friends. And so they were also waiting. And so I would just help them craft their story. And so and that started as a pretty young age. And that's when I really is almost like a jailhouse lawyer kind of thing, and getting their story straight and saying, okay, this is what you need to say. This is what you need to argue. And I was doing that 5th, 6th, 7th grade. So
what was your win-loss record? How'd you do?
Well, yeah, I mean, it's just coming up with something plausible. And so, and it had to be done quickly. So that was kind of on my feet thinking, and And that's where like I said, that I realized this is a job for me. I could do this. And it's,
and that led naturally into criminal law.
well, yeah. I mean, I was doing criminal and personal injury litigation when I started out, and that was my focus, and I thought I would stay there.
So when you went to law school, was crim already a focus? Was that going to the defense side? Was that like your act of youthful rebellion with your DA father? Like how did that how did you find yourself practicing crim first?
Well, I mean, when I got out in 93, 94, there was no hiring. It was just a terrible market. So I basically had to do whatever I could. And that was, so I went into private practice and right out of law school. And it was basically, how am I going to get cases? Well, I know friends who are in trouble and I can do criminal. And
Same thing.
Still doing it, just getting paid now. And then if they get into an accident or get injured, something like that, then I would do some personal injury law. So I kind of had this mixed practice, and it actually was working pretty good, at least initially. And, but it was kind of a roller coaster ride, just being all by myself and bringing in money and trying to pay the bills. And so, that's what I was doing. And then eventually started specializing in criminal defense. And then just doing more hardcore, criminal cases.
And so what happened with your criminal practice?
Well, so it was with criminals, a lot of criminals don't have a lot of money. This is kind of a problem. And so the white collar cases certainly would, but a lot of the other ones that I was representing didn't. And so I would end up getting paid up front for work, and then there wouldn't be really any money left over. So I would put in a lot of effort for a little bit of pay. And eventually it just wasn't enough to keep the engine going. And I enjoyed the work. I liked doing jury trials. That was fun. I felt like a lawyer doing that. But the pay was just too uneven. And, the bills were really kind of stacking up on me. And it was at that crossroads when I was thinking, okay, am I going to stick with criminal and somehow make this work? That there was a guy that had an office down the hall from me, Peter Walzer, who was a solo divorce lawyer, and he was looking for somebody to try cases for him. And I knew how to try a case, but I didn't know anything about family law. And we went to lunch a few times, and he kind of conned me into joining him.
What are the the differences in your approach? If you can go back to that moment, how did that change for you? I've heard you say in the past that you look at both sides as cleaning up different types of messes. So when you look at it that way, how do your approach change, or what do you still bring from the criminal law experience to your practice now?
Well, that was a struggle, and I'm sure anyone else here that came from a different practice area will see the transition into family law as a tough one, because as a defense attorney, we don't share anything. The prosecution has to prove everything, and it is trial by ambush. We show up there and put our case on, and we're not sharing any information with the DA until they hear it, generally speaking. And so obviously that mindset does not work in family law. And then also in other areas of law, like criminal, it's an element test, and you're either in or out. You're either, have the facts and the law to support a conviction or not. And in family law, it's very touchy-feely. There's only a few areas really that family law has any certainty to it, which was, I guess, the community rule of dividing equally, divide by two. Other than that, we don't have a lot of certainty in this area. So that was a very difficult transition to make. And so I feel what I'm doing now bears really no relation to what I was doing before.
So how did you transition from Peter asking you to do some trials for him to forming a law firm?
So initially I came on as an employee, and so I was just taking cases that he would give me and working them up and trying them. And so as that kind of progressed, and then we said, well, hey, let's form a partnership. And so we did that. We formed our partnership in 2005. So 16, I don't know, I'm losing track of time. I guess that's 16 years. And so, and that's a great model for certainly for somebody who's younger, who, if you're able to hook up with an older, more experienced lawyer, it's a really great model because Peter mentored me, provided, he introduced me to everyone I needed to know, told me what I needed to know. And so that was perfect and what I needed at that time. And then also he brought in the business side of things that I didn't have. So I was more of an artist type. I was like, send me in. I want to kill. I want to win this case. And I wasn't really thinking about the business side of law. But Peter was more really the opposite, thinking more of the business side of it. Hey, we got to get paid. We're running this as a business. What are we going to charge? What clients are we going to take? So it was a really natural fit. And that's another thing. If somebody's looking to form a partnership, it's a lot like a marriage, and you're going to get lucky, hopefully, with it, and it's going to last, or it's going to be a bitter breakup. But if you find somebody who looks at the practice of law different than you and has strengths in the area that you're weak, that would be somebody that would be great to partner up with.
So you guys are working, you got your practice cooking, you made a transition, then you hit this pivotal moment, and it ultimately became a 10-year saga with the Valley case. So let's get into our legal topic a little bit. How'd you end up with the case, and how was Frankie as a client? Let's start there.
Yeah. So Frankie had a long-term attorney who handled all of his business, Peter Bennett. And so Peter Bennett was tasked to find us and retained us. And at that point, it was me and Peter and maybe one or two other lawyers. Were a pretty small firm at that point in time. And so that was it was a big, interesting case. And just had every issue that you could think of it on it. And so that case did last 10 years, all the way from the trial level to Court of Appeal to California Supreme Court, and then started working back down to the lower levels of the courts until it finally resolved. But it was, I learned a tremendous amount from that case, and it is, I think, career defining for me.
Well, when it comes to the ruling that ended up on appeal, what were the facts, the initial ruling, and what issue ended up going on appeal?
Yeah. So in Valley, the dispute was really about Jersey Boys. So there was this Broadway play that was developed during the marriage, and it involved his life story and music before he ever married Randy. And all he did during the marriage was talk to the writer a few times about his premarital life story. And so that was the focus of the case. And there were two bifurcated trials before Judge Cronstadt on whether Jersey Boys had any community interest in it, which was phase one. And then phase two, if so, how do we figure that out and divide it? And so it was a super interesting issue because we didn't really have any law on that, on a person's life story. A spouse's life story is that property, and then the telling of the life story, is that enough effort during marriage to give the community an interest in it? So those were the issues we litigated. And in phase one, and the court said, yeah, there is some community effort here, more than minimal. So the community needs to get something. And then when we went to phase two, the issue there was how to quantify it. And we ended up proposing almost like a brokerage type fee. Like if somebody was selling a separate asset during marriage and there was effort of selling it, what would they get paid for that act of selling it, almost like a commission? And so Judge Kronstadt adopted that and came up with I don't know what it was, a 5 or 6% interest, which was obviously a lot better than 50%. And so that's the issue that I thought would have gone up on appeal, but it didn't. And in phase 3, before Judge Uhas, it was everything else. That was the kitchen sink trial. And there were every issue you could think of in phase 3. And one of them was a life insurance policy that Frankie had obtained during marriage, paid for with community property. It was like a universal life policy that he made Randy the beneficiary and owner of. And it was a tiny, tiny aspect of the case. It was a $3.75 million policy, but it was a tiny aspect of the case. And we said, well, hey, it happened during marriage, paid with community equals community. And Randy said, no, it was titled in my name, therefore separate. Judge Uhas said, no, community. And that was the issue that went all the way up to the California Supreme Court. We never saw that really coming.
So what happened after the initial ruling came down? Randy filed an appeal?
So yeah, Randy filed an appeal, and it went up to the Court of Appeal. And and Garrett Daly was the lead appellate attorney. I was the trial attorney. And so I assisted Garrett with the appeals. And we go to the Court of Appeal oral argument in Los Angeles. And I was there with Frankie, and I got to spend so much time with him. And honestly, that was the best gift out of all of this saga. Was every court appearance I would drive to court with him, and I just got to know him, and it just a wonderful man. And so we're sitting there listening to this, and we're thinking, okay, we're going to win this because it's a policy that's purchased during marriage. It's the funding of the policy came with community cash, admittedly. And the only issue that Randy had to argue was that it was titled in her name. And we know the title just doesn't really matter. And so we're thinking we're going to win this appeal. Randy's going to lose. And the Court of Appeal justice who was leading the oral argument was clearly on Randy's side and saying, no, it was put in her name. Frankie's sophisticated, or at least he has sophisticated people helping him. And that was a conscious choice. And by putting it in her name, it made it hers. And we're like, I can't even understand what's coming into my head, because you figure at the Court of Appeal, you got 3 justices, very well briefed, that this is the temple of justice, that we would be getting the best information here possible. But we're now hearing that title controls, and it was jarring. And so we kind of knew how that was going to turn out.
So you said you drove to every court appearance with Frankie. You're driving back after you just got dealt that loss. What was that like? How did you explain it to him? How did you counsel him going forward?
Well, and they don't deliver the outcome at the oral argument, but they certainly telegraph it, and so we kind of knew, and those are always hard, and I know, and maybe that's one of the best benefits of video appearances, is that we don't have to do the long drive home with the client if we're going together to court, because I've had a number of those, and they're not fun. And basically it comes down to win some, lose some. And, even though we don't guarantee the outcome of our cases, we do feel responsible about them. And because we put our heart and soul into these matters, and especially if it were on a factual issue, I get it. Hey, somebody's believed over the other. That's what judges have the right to do that. But on a pure legal question like this, it's hard. It's very hard to accept. And, fortunately, that wasn't the end of the story, but not fun to take a loss.
Well, on that topic, is there anything that you do before you go to court to prepare your client to manage their expectations?
Well, that's what I've been working on so much in the last number of years is managing those expectations. And basically, and that's our role. I mean, it's clients or decision makers. We give them the information that they need to make that decision. And it's just the same with a patient and doctor. We don't just, if we were the doctor, we don't just say, well, hey, you need surgery and I'm scheduling it for you. They need to give informed consent. And so for us to relay that information, we need to tell them the material risks of a course of conduct and explain that in a way that's understandable to them. And so I've been doing that a lot. It's our duty, but also it certainly helps because if we lose, then it's like, well, hey, I told you this could happen. Where I think the struggle is that clients, just as patients, hear the worst. And so if you're talking about all the ways they can lose, they think I am going to lose, or my attorney is no good. You don't believe me. I need to hire somebody else. And so that's important too, to talk about that, just because I'm giving you these risks doesn't mean that I'm predicting you're going to lose. I'm just giving you the information you need. But still, that's a lot of clients misunderstand that. They misunderstand it on the other way too. It's like, hey, client, you could get this. Well, they hear, I will get that.
Right.
So it's, I think having a couple different conversations, saying it in different ways, giving examples so they can really understand the information that they need.
Okay. Well, okay. So back to the Valley case. You've just gotten the ruling. It comes back that you lost on appeal. What happened next?
So we know we're taking that up. I mean, there's certainly the budget here. We don't have a lot of family law appellate decisions because a lot of people get wiped out at the trial level. And if they go to the Court of Appeal level, they're pretty much have no money left over there to go to Cal Supremes. And even if they do, the California Supreme Court, it doesn't have to take anything on review. So we don't see a lot of that, but we figured, hey, this was an important enough issue. We think the Court of Appeal got it wrong. And we had Brooks and Robinson, this other case that Valley Court of Appeal decision built off of, where there's now some conflict here in the law that hopefully the California Supreme Court would step in, and they did. So they accepted review of that. And so that was just awesome, because now this case is going up. Frankie has fame not only from his singing career with the Four Seasons, but now he's going to have fame for Marriage of Valley, and then hopefully justice will finally be served.
So what happens at that point when you have the Supreme Court argument?
So at the California Supreme Court, they usually do it in San Francisco, but at this time they also go on the road, and they were on the road in LA. So we come back to the same courtroom because that Court of Appeal shares the courtroom with the California Supreme Court when it's in town. So we're in the same exact courtroom. Now it's 2 years later or so. But we're in that same courtroom now with the Supreme Court justices sitting up there. And one thing that was interesting is that, Frankie and I again drive in, and we're sitting there, and we see the appellate justice who led the charge basically at the Court of Appeal level walk into the audience to listen now to the California Supreme Court reviewing his decision. And so we're listening to this, and we know pretty clearly from the beginning when Justice Chin starts his questioning and talking about the community property rule in Family Code Section 760. And this is what we've been briefing and preaching in any question of characterization starts with Family Code 760, which is, except as otherwise provided by statute, all property acquired during marriage is community. And often people, when they're saying it's not community, it's separate, they'll cite a case, or they'll say, this is the way we always do it, Judge. The cases and folklore don't count. It has to be a statute. And so it's always show me a statute is what we were arguing. And Justice Chin said to Randy's counsel, Bill Ryden, who was arguing it from what was then Jaffe and Clemens, where's the statute? And when he said that, we knew we won, because there is no statute that makes this separate other than the one they were arguing, which is the title presumption in the evidence code. But as Justice Chin held in his opinion, that the statute to rebut 760 has to address characterization, and the title presumption only addresses ownership. It doesn't address characterization, so it really can't be used as an exception to 760.
And after the arguments ended, you were pretty confident of what the outcome was going to be. How long did it take for the ruling to come in?
Well, it took a bit. We knew we won that. And it took a bit, months, I would say. And at some point in that waiting period, and I think it was possibly after the oral argument, but perhaps before we got the decision, Randy Valley passed away of cancer. And she was younger than Frankie by 20 plus years. And that's why she was fighting over the life insurance policy, because she figured he was going to predecease her. And it didn't turn out that way, and that's the tragic element of this case, because no divorce case should go on 10 years, and no one should spend really any part of their life fighting, and certainly not their last years fighting. And that to me it was a lesson about choices that we have and the advice that we give to our clients, because life is so precious. And do we want to spend that fighting? Do we want them spending that fighting? And for them at least to think about that.
Did you have any other takeaways from the final outcome in that case?
Well, to me, it wasn't remarkable. It was like, duh. It's like, do we really need a California Supreme Court case to say if you buy something during marriage and you spend community property on it, that it's community? But obviously we did. And so it did help with that title presumption. I still see attorneys still arguing for title controls. No, it really doesn't. I mean, it can if you put it in community, sure, that controls under 2581, but putting it in separate doesn't control, and or sole title doesn't control. And so the case did have a legacy. And I do, and it's been so long now. And I think some people, just will cite that case, or judges will cite that case in other matters that I have. And I think not knowing that I was involved in it, and sometimes maybe get it wrong. So it's kind of entertaining to see how that case has been used. But yeah, it was just a great journey for me for 10 years and to get paid for it too, which was awesome. And to go all the way up that high in make law. And so very, very positive experience. And again, all out of an issue that we never saw coming. And so this is maybe one takeaway is that the issue that you're trying and focusing on may not be the one. And so if you're going to trial, it's really look at all those issues, make sure that they're briefed, make sure that your arguments are preserved, because you don't know which is the one that's going to go up.
When that case does get cited back to you, because it is a well-known case, and especially if somebody gets it wrong, do you correct them, or you just kind of have a little internal smile and take a little moment of pride in what you put on the books?
Yeah, I think I'm just do it internally, because I'm not into really wanting to correct people or show off or anything like that. And I think especially these last number of years here, that I've just realized what I don't know. And pretty much my whole life before that, was I thought I knew everything. And now I realize that there's so much that I don't know. And that mind shift to me has really been liberating, because I want to learn from other people, and I'm not just sitting there talking to other people. I'm doing a lot more listening now.
So this case, clearly major turning point in your practice, not just in your professional development. And since then, and we've touched on it a little bit, your growth as an attorney and a businessman, especially. I want to transition into that a little bit. So specifically from Valley, I'm getting a lot of like confidence elements that came through that case and that long process. How did that specifically impact your practice and propel it from that point forward?
Well, that's important when you say about confidence. And when I'm like mentoring other lawyers, talking to other lawyers about their career and their development, and especially with younger lawyers that are starting out, and I'll propose something like, hey, why don't you write an article? Why don't you join this committee? Or why don't you speak at a seminar? And a lot of times it's like, well, when my resume is built up a little bit more, I need to have more of this or that before I can go to that level. And I think that's a big mistake, because it really starts within, and no one's looking at anybody's resume, and your resume is never going to be finished until you retire. And what I've learned, and this was difficult, because at first when I started charting out my career, I thought, well, I'm going to be the best trial lawyer out there, and people are going to want to hire me. Well, that didn't happen in criminal, because nobody knows that I'm trying these cases except the judge, the DA, and the guy that's on trial. And so I just can't reach an audience that way. And then I would find these other lawyers that were super successful that were terrible lawyers. And it's like, how could this possibly be true? Well, it's true because they're good at marketing. They're good at branding. They're good at getting their message out there. And then they just find somebody else to do the trials for them. And so once I realized that, I said, okay, well, I can be good in court, but I also have to be good in business. And I have to learn how to market myself and brand myself, get my message out there. And that was a big shift. So that I could grow, because it's just waiting for cases to come in or the phone to ring isn't good enough. You gotta shake the tree. And that does start with confidence, and it starts with proclaiming it. And so that would be the recipe for my secret sauce, would be number one is proclaiming it and figuring out, what do you want? And to me, it's been, I want to be one of the top family lawyers, and I want to also be one of the highest compensated family lawyers. And so I'm proclaiming that. Now that's a horrible goal. It's a terrible goal to have. I should be saying, I want to be the best dad, and I want to be the best husband, and I want to have the most hobbies, but I didn't do that. So I set my goals on the career, and then I went to the second part of it, which is, okay, what is my plan? How am I going to make this happen?
Are those goals mutually exclusive in your opinion?
Yes.
Okay. And so go ahead.
Well, you can't, I mean, I'm hoping now that I'm trying to do, so like I've been mountain biking a lot, so I'm taking out some time to do something for myself. I'm looking at some hobbies that I might be able to do. I'm spending more time with my kid. But it's hard. I mean, before it was very difficult to balance. And I'm the kind of guy that if a client calls me at 2:00 in the morning, I might get up and take a shower or something like that, but I'm going to get on that call, and as long as they're paying their bill. And so or if I'm at dinner and we're in the middle of something and a call comes in, an email comes in, it's important, and a paying client, I'm going to say sorry and step aside and take the call. And that's a terrible, terrible way to be, but it has made me successful.
So it sounds like you're saying, if your goal is to be the top family law attorney, you have to prioritize your practice?
Well, that's what I did. Now, I think there's people out there that are a lot smarter than I am and that are more balanced and have boundaries. And I think they would argue with me and say, no, you can do both. And I think there's examples of people who have done both. I guess when it came down to it is that I'm just too scared to try that. And even now, when I don't necessarily need to be so available, I'm scared that if I'm not, that they won't want to use me, or they'll go somewhere else, or they won't pay me. So it's probably my failing that makes me overcommitted. And I wish, and if there's people out there that got the balance, you please hit me up and let me know what your secret is, because it's a really is not a great way to live.
So I want to turn that around, right? Because you mentioned that you mentor a lot of other attorneys. You're also clearly very self-aware. So how do you assess their practices, knowing that not everybody fits into your mindset?
Yeah. Well, that took me a while to learn. And it was only really recently that I realized that not everyone thinks the way I do. And that was difficult, with a difficult adjustment, I think, is that I've just figured, well, everyone else wants to take over the world and make all this money and do this stuff. And no, there's actually normal people out there that want to have a life, and they want to be with their family, and they want to have hobbies, and they want balance in their life. And so what I've learned is there's not a one size fits all, so I'm just, when I'm working with other attorneys and talking to them about what their goals are and how to achieve them, it's first of all understanding is that what does your perfect life look like? Where do you want to be in 5 years? And if it's saying like, hey, I want to retire, I want to be taking vacations and doing stuff like this, then we know that the plan has to be adaptable for that. That it can't be just hardcore 24/7 billing.
I want to go back to something that you mentioned, the different marketing approaches and the business side of things that you slowly learned about and have prioritized more and more in your practice. What has worked and what hasn't worked for you?
So what's worked for me and the firm is, I mean, we get pretty much all of our business from other family lawyers. And I learned that when I started working for Peter, and I was like, well, this makes no sense. Why would a family lawyer, especially one in Los Angeles, give you any work? Well, his dad, Stuart Walzer, who was a great attorney and a really great businessman, had taught him that. And really what it is, and I didn't know this until I started studying marketing, especially after the lockdown. I really dove into understanding what marketing is, but it's a form of what they would call content marketing, which is you're putting out seminars on family law topics, you're writing articles on family law or blogging on family law, and so that people then see you as an expert in or passionate about a particular area of law. And then they just identify you as somebody that they would want to hire for a case, either as a consultant, co-counsel, or to refer to you. And so it's a very effective, more of a soft sell approach. And so that has worked for us. And that's how I learned family law, by doing all these seminars. And I've done probably 200 CLE seminars. I learned that way because I didn't want to make a fool of myself. So I figured I'm going to study this topic inside and out and be prepared to answer any questions and have good materials. And that's how I learned family law, more than handling cases. And so that's worked. I think what doesn't work, at least for our practice, is, big advertising, because it's like we're not, when we're trying to get these big cases, these clients are not going to respond to an ad, and they're probably not going to Google for a LA divorce lawyer. They're going to go to their business manager, other attorneys that they know, and say, find me the best family lawyer in LA. And it's those folks who are going to actually then do the work and maybe know us. So any kind of marketing that's targeted directly to the client doesn't work for us because we're trying to get these big wealthy clients. So when we're focusing on the type of client that we want to get and how that client is going to find the lawyer, then we're in business. And then really just using now social media and video to keep connections alive with our contacts and then make new contacts. And like LinkedIn, for example, is just a great place to meet other lawyers all over the world and have a conversation with them and actually create a relationship with them. It's not superficial.
So you've mentioned it a couple times, the importance of having the right book, the right client mix, so you can collect your bills on time and keep the practice running. Can you unpack that a little bit for us and talk about how you deal with that data? I know that's such a big challenge in the community.
Yeah, I mean, I think it's for us. I use a fishing example. Like, you have to look at what type of client that you want, and then that determines what kind of practice you're going to have. And so my fishing example is that if you're looking for a whole bunch of small clients, you're like the sardine fisherman, and you're going to have this huge boat with a big net cast out there, and you're going to drag it across the ocean. You're going to come up with just millions of sardines and dump them in the boat and sell them for whatever you can sell them for. That's one way, and you can make it probably a ton of money doing that. The other, but that firm is going to look a particular way. There's going to be 1 or 2 lawyers and 50 paralegals, and they're not going to charge a lot of money, and there's not going to be a lot of contact between client and lawyer. It's going to be very much a processing thing. The other extreme where we're at is a small number of huge cases. So in the fishing analogy, we'd be going after the bluefin tuna, and we maybe say we're going to have this little boat and very specialized and one line in the water, and we may go out for days and not catch anything, but when we do, it's a big one. And so that firm, like ours, looks totally different. Mostly lawyers, very little staff, high fees. So the whole makeup of the firm is going to be dependent on the type of clientele that you want. And then what's super important about it is making sure that we're paid, because this is a trap we all fall into. And it's very easy when a client calls and is an interesting matter and works you up and tells you how great you are and how they need you, and you want to dive in there and help. That's what we're service providers. But then we forget, how's this person going to pay? And then if they are signed up as a client, when they're not paying, what are we going to do about that? Because we can't just give hundreds of thousands of dollars of legal services away to essentially a stranger.
And so how do you deal with that problem?
Well, fortunately, here at the firm, we have meetings every 2 weeks where we go over the receivable list. And we also have standards about intake of a client. But once they're a client, we have the receivable list. We go through every 2 weeks, and we know exactly who owes us what. And if it's my case and there's this gigantic receivable, my partners are going to openly mock me. Like, what are you doing? Why are you carrying this client? Like, who is this person to you? What are you doing? Are you willing to use your paycheck to fund this case? And so that helps because there's accountability. And what I would recommend is that if you're a solo, is find a buddy and have another family lawyer act as that sounding board. And every 2 weeks, go through your receivable list together. It's not going to take that long, and don't hide it. Don't hide the $200,000 you're not case. Show that to your buddy, and they will say, "Why are you doing this?" Look at what you could at the time. And this is where it really enrages me, because like I said before, I'll interrupt dinner with my kid to take a phone call with a client. And what the client's promise is, I'm going to pay you. And when they don't pay me, you basically just robbed time from my kid. That's the way I look at it. And so it's a two-way street. And so I think accountability, and if you're a solo, find that buddy, go through the list and have them hold you accountable. And you will see, you're going to get rid of the bad clients. You're going to be more selective about who you bring in. You're going to, because if we collected everything we build, we'd all be rich. And there's no reason. And when you have the client who isn't paying, we're so busy working on that case that the one client that comes in who actually can pay us and wants to pay us, we can't help because we're still engaged in this other matter. So the power of no is it should not be overlooked. It's no, I will not take your case. You can't afford me. No, I will not continue representing me. And I'm going to file a motion to be relieved because you haven't paid.
And how are receivables handled in your office? Is that through each attorney, or is there a managing partner or another individual?
So we're looking at this list, and it's the client. I mean, the attorney who's handling that client is ultimately responsible to make sure that the communication is happening. And so we have a staff member who will be following up and sending the bill and sending reminders. And we also have a flow chart basically of our expectations. We send the bill by the 10th of every month. No questions asked. Every bill for every client goes out by the 10th of every month. And then between the 10th and the 30th, we're in collection mode. And so we're reminding the client, hey, have you got your bill? Why haven't you paid? Here's a credit card link. Please pay us. And then as we get towards the end of the month, we're getting our second receivable report to say, are we going to go on the merry-go-round another month with this client? And so it's a system rather than, oh my God, this person owes us $1 million. How did that happen?
So in the couple minutes we have left, Chris, I want to zoom all the way back out. We've covered so much ground today. And maybe it's a bit premature, but do you feel like you're starting to have a vision for your ultimate legacy in the community? Is that starting to come into focus here?
Well, I mean, what I'm hoping to see is more collegiality in the practice, because, and I'm looking through this list of folks here that are on here. So many of you have helped me and been mentors to me and friends to me and supported me. And that's what makes this a tolerable job. And so what I think is that power of kindness and giving is what I'm hoping to give back to other attorneys, ones that are starting out or struggling or want to get to the next level. And I'm hoping you'll contact me. I'm happy to share some tips. But we're in this together. Yes, we may be fiercely, vigorously fighting together in a particular case, but we're in this profession together and we can support each other and help each other. And so I'm hoping we're going to see more of that, because that's helped me out tremendously in not only feeling good about being a lawyer in this area, but also getting cases through not being a complete maniac and killing all these relationships. So there's financial benefit out of it too. And the other thing is thinking about succession planning, because we can't have all these firms run by people in their 70s. There has to be a changing of the guard, and we need to groom and support and promote other folks that are entering our profession, and to show them the secret sauce, show them the path so that they can take over. Because my kid's, he's 11 years old. He's not taking over my practice. So who is it going to be? And like I say, I think that it's here for the taking. This has been around for a long time. We've been through the last year. We know we can survive that. We can survive anything. And we're much like what I look at it as undertakers. There's always going to be people dying and they need to be buried. There's always people who are going to be divorced. They need divorce lawyers. And we're in a recession-proof business. And it's like a gold mine, but we have to know where to dig and how to get the gold out of the ground and where to sell it.
Chris, I can't think of a better note to end it on. And we're right out of time. Thank you so much for sharing your experience with all of us here. I know I learned a ton as a young attorney who's, going through all those things that you did many years ago. Well, that wraps up our first episode. Please mark your calendars and join us for our next episodes, which will be the first Wednesday of every month. We have April 7th with Laura Walzer and May 5th with Judge Lewis. They're both going to be at 12:30 p.m. Registration links are already posted on the BHBA calendar, so you can sign up now. And thank you especially to Genna and Alex at the bar and the Family Law Executive Committee led by Carrie Holmes and Ron Reitshtein and of course, all of our section sponsors. Again, thank you so much, Chris, for being our first guest and for being so open with us. Have a great rest of the week, everybody, and we'll see you next month.